Good morning, ladies and gentlemen, and welcome to that episode of PLA with myself, Nick and Bruno. We're going to jump into two questions as always. The first one with Nick, and the second one with Bruno. The first question goes as follows, Nick. We have been approached by a couple whose son owned an apartment. Their son has unfortunately passed away last week, and they would like to start renting out the apartment as soon as possible to cover the costs. His father, the father of the son, is appointed in the will as the executor, but he says that this has not been settled by a magistrate in court yet. Can he then, Nick, sign the mandate and lease agreement as the executor, right? And the writer is also under assumption that they would put the personal details of the deceased owner and the executor on all documents. So is that true? As well as information around which other documents should they be requesting in terms of FICA for the executor. Nick?
Okay, perfect. So I just want to deal with, to start off, what happens when someone dies and you have a will where you appoint a person who's going to be the executor of the estate. Now, in terms of the question, what they said is that the father has been appointed as the executor, but they said that that hasn't been settled by the magistrate's court. Now, unless there's some process we don't know about that involves a magistrate's court at this juncture, magistrate's court are not the guys that appoint an executor to an estate. So just as an important note, you don't wait for a magistrate's court to appoint an executor. That function within our law is designated to the master of the court. Okay, so the master of the high court, they are the ones that are going to appoint an executor, and in order to do that, they issue what's called a letters of authority. Okay, so your letters of authority say who are the people that are appointed and authorized to deal with the estate of the deceased person. Okay, now what is important to know is until such time as letters of authority have been issued by the master of the court, no one is authorized to do anything on the estate whatsoever. Okay, the only time that you can start administering the estate and dealing with the deceased person's property with any authority whatsoever is after those letters have been issued by the master. The master's generally quite on top of this process, because obviously them taking long is an absolute nightmare for the administration of people's estates, and exactly circumstances like this where there are properties that are hanging in the balance. Okay, so the first thing is, please understand those letters are really needed, and nothing that happens before that can be authorized until such time as those letters are done. And the master generally won't take long to issue those letters. So, you know, I see in terms of the question they're saying last week. I'm not exactly sure what the time period is, but this is not a long process. So really waiting for the letters would generally be my advice in all circumstances, just to make sure that there's no question about the contract, or you know, there are a lot of functions that executors hold and a lot of things that they do within a particular estate when winding up an estate. And what you don't want to do is start taking actions prematurely that then become a question mark later, either by you know, creditors of the estate, or the master questions the actions at a later stage to say, actually, what actions you've taken here were not authorized in any particular way. So waiting for those letters is generally the safest option. Just wait. It shouldn't take a long period of time if the master's functioning in their normal capacity. That being said, okay, obviously, you know, when people unfortunately pass away, we still exist within a moving economy. And so there are certain circumstances where, you know, for instance, maybe not in this particular circumstance where the executor is trying to enter into a new agreement. That can always be a bit of a nightmare, okay? But where things have to still function in the course of waiting for the master to issue its letters to the executors in the circumstances. In those particular circumstances, if someone is going to be the executor and there's not really a fight on the will on how that's going to happen, and certainly not a circumstance where someone has died intestate, in other words, without a will, there are certain actions which I do often say to executors, look, just make sure that this thing is continuing to function until such time as you've got the proper authorization in hand. Okay, and those, say for instance you've got a tenant who's already in a premises and he's got to pay rental. Okay, it does help that you make sure that this thing continues to function in the interim until you get your letters of executorship, and then you can function and handle the estate in whatever way you want. So sometimes that does help. But what I would recommend to this person is, for the sake of safety, and this shouldn't be a long process, I would say wait for your letters of executorship. Once those come out, this should not take a long period at all. Go ahead. You can enter into the lease if you really need to, or handle the property in any other particular way. But until such time as that happens, I'm afraid it's a little bit risky, just because from a legal perspective, entering into that lease agreement, absolutely not authorized and probably unenforceable at the end of the day. Bruno, I don't know if you've got a different view from me on that.
No, I totally agree with you. I think we've had this conversation before a couple of times where the practicalities behind it does depend on the master's office. So that's the one problem, is some master's offices are faster than others, and some estates are more easily dealt with than others. So, for example, if you have a will and there's an executor appointed, it typically tends to be easy for the master to just confirm that executorship. But if, for instance, there's a dispute or it's intestate and it's not obvious who the executor is going to be, that creates a world of trouble. So, to Nick's point, if you know you're going to be executor, if there's no family feud about executorship, if you're acting in the best interest of the estate, is it totally legal? No, but are there consequences to you putting the money aside, not using it, or using it to cover expenses, but just, keeping the money coming in? I don't think anyone's going to fault you for acting in the best interest of the estate. If now you start distributing the money and saying, well, you know what, it should go towards the maintenance of this person and that person, and you're not 100% sure whether that would actually be legal, that could end up being a problem. So there is a level of like almost fiduciary responsibility. And again, this isn't advice saying go for it, but one does understand that you can't sit with the property empty, because the long-term ramifications are even worse. So trying to make sure that there's some income that comes in order to cover some of the expenses isn't the worst thing you can do, but then don't just go out and utilize the money.
Yeah, I think what ultimately the last real point is remember, if you are going to practically manage these things before the letters are actually issued to you, you're still going to have to account to the master at the end of the day. Yeah. They're going to have to tick off that this has all been handled properly. So there's certainly no way that you can take in money and start distributing it as you want. It's going to have to be accounted for with the master, and ultimately you only hurt yourself if you start acting in a way that the master's not going to like at the end of the day, because they're not going to give the tick off on the final L&D account, which is made.
Exactly.
It's crucial. Right. So thank you very much, gentlemen, for that response.